Plus, we'll hear testimony from senior intelligence officials from the NSA, the Justice Department, and the Office of the Director of National Intelligence. The hearing's being held by the Senate Judiciary Committee. This is live coverage on C-SPAN 3.
Okay, if we can get started, because I know with all the other things going on in the Hill, it's going to be a tad busy today, but I appreciate General Alexander, Mr. Cole, and Mr. Litt being here. We're going to be renewing our examination of government surveillance activities, and it seems every time we have these, there's been a series of new revelations. And the latest disclosures raised some significant questions about the scope and wisdom of our surveillance activities, both at home and abroad. So it's clear that we have a lot more oversight work to do. In the last week, there have been press reports that the NSA is collecting billions of records a day of cell phone locations around the world and can track individuals and map their relationship. There have also been reports the NSA is monitoring online video games, which, just in the press reports, raises the question, because we can do something, does it really make sense to do it? Especially as last month the administration released a set of documents revealing details about yet another massive dragnet collection program, in addition to the phone record program. And this time, the NSA was gathering in bulk an enormous amount of Internet metadata under the PEN Register and Trap and Trace Device Authority in FISA. Now, I just note that just like Section 215, there is nothing in the PEN Register statute that expressly authorizes the dragnet collection of data on this scale. Although the Internet metadata collection program, we are told, is not currently operational, it resulted in a series of major compliance problems, just like the Section 215 program. According to the FISA court, the NSA exceeded the scope of authorized acquisition, not just once or twice, but continuously during many of the years the program was in operation. Again, another reason why we should have a lot more oversight and a lot more open oversight than we do have. The problems were so severe, the FISA court ultimately suspended the program entirely for a period of time before approving its renewal. But once renewed, the government asserted this bulk collection was an important foreign intelligence tool, which is the claim it makes now about the Section 215 phone records. But then, in 2011, the government ended this valuable tool, as they call it, this Internet metadata program, because, as Director Clapper explained, it was no longer meeting operational expectations. It's important that the administration does not believe there's any legal impediment to restarting this bulk Internet data collection program if it or a future administration wanted to do so. The legal justification of this Internet metadata collection is troubling. As with the Section 215 program, the Internet metadata program was based on a relevance standard. And as with the Section 215 program, there's no adequate limiting principle to this legal rationale. The American people have been told that all of their phone records are relevant to counterterrorism investigations. Now they're told that all their Internet metadata is also relevant and apparently fair game for the NSA to collect. In any country, this legal interpretation would be extraordinary. It goes beyond extraordinary in the United States. And it's going to have serious privacy and business implications in the future, particularly as new communications and data technologies are developed. So it should come as no surprise that the American technology industry is greatly concerned about these issues. I've heard from a number of companies who worry that their global competitiveness have been weakened and undermined. They say that the American businesses tend to lose tens of billions of dollars in the coming year, and we need to make substantial reforms to our surveillance laws to rebuild confidence in the U.S. technology industry. This confidence can be thrown away very easily. It's more difficult to get it back. Earlier this week, 8 major technology companies, including Microsoft, Google, Apple, Facebook, and Yahoo, released a set of 5 principles for surveillance reform. And citing the urgent need to reform government surveillance practices worldwide, the companies call for greater oversight and transparency. But they also advocate for limits that would require the government to rely on targeted searches about specific individuals, whether the bulk collection of Internet communication from all of us. I've introduced the USA Freedom Act with Senator Lee here in the Senate. Our bill takes many of these steps, so I appreciate the support we've received from the technology industry, and I look forward to hearing their perspective on the second panel. And without objection, I'll place on the record the open letter and reform principles from the technology companies, and an earlier letter from technology companies applied in the USA Freedom Act, and a supportive letter from a coalition of civil society organizations, companies, trade associations, and investors. And without objection, I'll be part of the record. And support for the technology industry is representative of the broad-based bipartisan support for our legislation. Organizations across the spectrum have endorsed the bill, from the ACLU to the NRA. I thank Senator Lee and Senator Durbin, Senator Blumenthal, Senator Hirono for their co-sponsorship. And this is bipartisan. It's also bicameral legislation. It's a common sense bill that makes real necessary reforms. So I want input on the legislation. I look forward to working on this in the coming months. I do want to thank our witnesses for being here today, especially after we had the unexpected cancellation in November. Senator Grassley, I know you have a half a dozen conflicts on your schedule. I thank you for being here.
Yeah, thank you. Of course, this is a very important hearing, and you're doing the right thing by having the hearing, because this is a subject of ongoing media attention and a lot of constituent interest. We last held the hearing in early October. Since then, reports have continued to surface in the media about possible overreach on the part of government. Some of the reports may be more accurate than others, but I continue to believe that many of them call into serious question whether the law and other safeguards currently in place strike the right balance between protecting our civil liberties and our national security. And that balance is a very important balance, but it's a balance that for personal liberty as well as national security both have constitutional implications. You can't forget one or the other. This is especially so concerning the public revelation that under Section 215 of the Patriot Act, the government is collecting American phone metadata in bulk. Why are many Americans so concerned? Well, it isn't hard to find an example of what can happen to Americans' personal information when the government overreaches, mismanages, and fails the American people. It's been 2 months since the administration tried to bring Obamacare website online, and the American people are suffering under that issue. Many finding they can't keep the insurance they planned and liked. Their premiums are rising, and uncertainty is growing about which parts of the law the president will decide to uphold. But in just these few months, we have already seen reports of incidents where Obamacare hasn't adequately protected Americans' personal data. In one reported instance in Minnesota, an insurance broker was accidentally provided the personal information of 2,400 people. Moreover, there are many unanswered questions about the website's ability to protect privacy going forward. Now, I expect, in fact, I understand that the standards of the dedicated professionals in our intelligence community do not compare to those of the contractors who failed to set up the website that I've referred to. But it's easy to see why many Americans tend to be skeptical then that the government can adequately maintain their privacy when it collects vast amounts of information. The President's disengagement on these important matters doesn't help. He claims he was unaware of the problems with the Obamacare website before it was launched. Now reports say he was unaware of the reported surveillance of many world leaders. As I did back in October, I called on the President to lead. Many of these programs are critical to our national security. The President needs to contribute to the national debate by publicly explaining and defending them. For instance, a visit to Fort Meade would help the morality a great deal. It's good that there are numerous reform proposals that this committee will have the opportunity to consider going forward. I'm convinced there is a role for greater transparency, oversight, and accountability in the FISA process. The public trust of our intelligence community must be rebuilt. And of course, we must ensure that intelligence authorities are exercised in a manner consistent with our laws and Constitution. These proposals should be subject to the same rigorous and critical examination to which we're subjecting the surveillance programs themselves. These proposals should address the specific concerns that have been brought to light, not to relitigate old and irrelevant legislative battles. These proposals shouldn't provide a terrorist abroad with rights similar to those of U.S. citizens here at home. These proposals shouldn't make it more burdensome for authorities to investigate a terrorist than it is to investigate a common criminal. And these proposals shouldn't return us to the pre-September 11th posture. Then, we didn't adequately weigh the dedication, intelligence, and lethality of our foreign enemies, who are undoubtedly watching the debate very closely. The balance between protecting individual liberties and our national security is a delicate one. And reasonable people can disagree about precisely where that balance must be struck. And that's our responsibility here in the Congress of the United States. Our witnesses on both panels today represent a wide range of view, and I look forward to hearing their point of view. And before you start, Mr. Chairman, I'd like to explain further something you brought up, that I had a conflict. At 2:30, Secretaries Kerry and Lew are briefing senators about the classified details of the controversial nuclear agreement the Obama administration has made with Iran. I'm skeptical of that agreement, but I have a responsibility to learn more about it. But I have to weigh going to that hearing to be here because I'm also, as leader of the Republicans, know the importance of FISA and whatever work is done there for our national security as well. The chairman did accommodate us to some extent by moving this ahead by a half hour. I'm going to stay beyond that half hour anyway to ask questions at least of the first panel. I had asked the meeting to be rescheduled, and it's the chairman's prerogative to lead this committee as he sees the necessity to do it. But I think it's too bad that this could not be worked out so that senators could attend both of these matters together. Thank you, Mr. Chairman.
Well, thank you. And I wish I could be at the other hearing too, but we've had to reschedule this once already, and everybody has agreed to be here today, and I didn't think it was fair to our witnesses to reschedule again. Besides, if a lot of these classified briefings, like the one you just referred to, I've had to miss in the past because of conflicts, but I find I can usually read almost all of what was said there in the paper the next day anyway, usually in more detail.
I agree with you on that point, but also
I'll share my news.
It kind of makes a mockery of what they call secured, if that's
Well,
okay.
if it's, it depends upon whose ox is being gored, I guess, as it's more of a question who can get it out quickest. I do recall one of these very highly classified matters and that we had, and the very first thing that came up marked top secret was a photograph of the cover of one of that week's news magazines, and it went downhill from there. Our first witness is General Keith Alexander, is the Director of the National Security Agency, head of U.S. Cyber Commander, began his service at the U.S. Military Academy at West Point, Previously served as the Commanding General of the U.S. Army Intelligence and Security Command and Director of Intelligence, U.S. Central Command. And of course, one General, I thank you for being here. Your full statement will be made part of the record, but in the time you have, please feel free to hit any points you want or summarize any way you'd like.
Chairman, thank you, and I'll keep my opening remarks short, but I would like to hit a few key things. First, NSA is a foreign intelligence agency. Those acts and tools that we do are to connect what we know about foreign intelligence to what's going on here in the United States. We need tools to bring that together. I want to talk briefly about some of those tools. And some of those tools, like Section 215, in my opinion, and I think in the courts, are constitutional, were authorized by Congress, they're legal, they're necessary, and they've been effective. From my perspective, the threats are growing. When we look at what's going on in Iraq today, what's going on in Syria, the amount of people killed from 1 September to 3 December is over 5,000 from terrorist-related acts in Iraq, Syria, and several other countries around the world. In Iraq alone, in 2012, the total number killed were 2,400. From 1 September to 3 December, that has risen to 2,200 plus in a 3-month period. It's on the verge of a sectarian conflict. The crisis in the Middle East is growing, and the threat to us from terrorist activities, our safe havens, and those being radicalized are growing. What we found out in 9/11, and I go back to Senator Grassley, your comments, we can't go back to a pre-9/11 moment. Sir, I absolutely agree with that. So we have to find out what is the right way for our nation to defend ourselves and our allies and protect civil liberties and privacy. I think the way we're doing Section 215 is actually a good model, not just for our country, but for the rest of the world. It has the courts, Congress, and the administration all involved. Why do I say that? And the reason is, if you look at all the information that is out there, the billions and billions of books of information that are out there, there is no viable way to go through that information if you don't use metadata. In this case, metadata is a way of knowing where those books are in the library and a way of focusing our collection, the same that our allies do, to look at where are the bad books. From our perspective, from the National Security Agency's perspective, what we do is get great insights into the bad actors overseas. Armed with that information, we can take the information, the to from, and what I did is I put that on a little card. It says from number, the to number, the date, time group of the call, and the duration. That's the elements of information we use in the 215. There is no content, there are no names, no email addresses. From my perspective, that is the least intrusive way that we can do this. If we could come up with a better way, we ought to put it on the table and argue our way through it. The issue that I see right now is there isn't a better way. What we've come up with is, can we change one? But Senator Grassley, you brought out a great point. 9/11, we couldn't connect the dots because we didn't have this capability to say someone outside the United States is trying to talk to someone inside the United States.
Well, we also had people in the administration that refused to listen to FBI agents who had picked up on what was happening here in the United States when they were told it's not important, even though anybody with a brain in their head would have known it was. But go ahead. I understand your point, and thank you. And let's stick to the facts. We're not talking about a library. I had my first library card when I was 4 years old. I understand libraries. Let's talk about the NSA.
Well, I think the important part for us, Mr. Chairman, is how do you bring information that you know from outside the country to that which we have inside? How do you connect the dots? And that's the issue with the metadata program. There is no other way that we know of to connect the dots. And so that gets us back to, do we not do that at all? Given that the threat is growing, I believe that is an unacceptable risk to our country. So what we have to do is, can we do more on the oversight and compliance? And there are things that are being looked at. But taking these programs off the table, from my perspective, is absolutely not the thing to do. I do agree with this discussion with industry as well that you brought up, Chairman. Industry ought to be a player in there. They have been hurt by this, and I think unfairly hurt. we ought to put this on the table from two perspectives. Industry has some technical capabilities that may be better than what we have. If they have ideas of what we could do better to protect this nation and our civil liberties and privacy, we should put it on the table. And I think we should have a way of bringing government and industry together for the good of the nation. And we ought to take those steps. So, Mr. Chairman, I just want to end with this statement. We're a foreign intelligence agency. Our job is to figure out what's going on outside the United States and to provide that level of information to the FBI and others who are operating inside the United States. To date, we've not been able to come up with a better way of doing it. I'm not wed. I don't think anybody at NSA or the administration is wed to a specific program, but we do need something to help connect the dots, something that can help defend this country. And I think these programs have been effective. That's all I have, Mr. Chairman.
Thank you, Chairman Leahy. Ranking Member quite all right.
James Cole first joined the Department of Justice in 1979, served for 13 years in the Criminal Division. He later became Deputy Chief of the Division's Public Integrity Section before entering private practice and was sworn as the Deputy Attorney General on January 3rd, 2011. Please go ahead, Mr. Cole.
Thank you, Chairman Leahy, Ranking Member Grassley, and distinguished members of the committee for inviting us here to talk about the Foreign Intelligence Surveillance Act. I'm going to focus my opening remarks just on the 215 program. As has been mentioned, it involves the collection of metadata from telephone calls, including the number that was dialed, the date and the time of the call, and the length of the call. It does not include the content of any phone calls, any names, addresses, or financial information of any party to the call. And under 215, it does not include any cell site location information. The government can search this data only if it has a reasonable, articulable suspicion that the phone number being searched is associated with certain terrorist organizations. Only a small number of analysts can make that determination, and that determination must be documented so it can be reviewed by a supervisor and later reviewed for compliance purposes. And only a small portion of these records actually end up being searched. This program is conducted pursuant to authorization by the FISA court. Since the court originally authorized this program back in 2006, it has been reapproved on 35 separate occasions by 15 individual Article III judges on the FISA court. Oversight of the 215 program involves all three branches of government. Within the executive branch, numerous entities in NSA, the Department of Justice, and the Office of the Director of National Intelligence are involved in assessing compliance. We report any compliance incidents to the FISA court immediately. With respect to Congress, we have reported any significant compliance problems, such as those uncovered in 2009, to the Intelligence and Judiciary committees of both houses. Documents related to those 2009 problems have since been declassified and have been released by the DNI. Over the past several months, we have also gone to great lengths to better explain publicly why the program is lawful. Under Section 215, there must be reasonable grounds to believe that the records that are collected are relevant to an authorized investigation to protect against international terrorism. As both the FISA court's opinions and our own 22-page white paper explain, relevant is a very broad term. In its ordinary sense, information is relevant to an investigation if it bears upon or is pertinent to that investigation. Courts have held that large repositories of information can satisfy a relevance standard where the search of the whole repository is necessary in order to identify the critical documents. This is precisely the rationale that underlies the 215 collection program, and it was recognized by the FISA court. The court found that the entire collection of bulk metadata is relevant to an authorized international terrorism investigation because it is necessary, a necessary part of the process to allow NSA to identify phone calls between terrorists and other persons. As Judge Egan's recent opinion reauthorizing the program recognized, and I quote, because the subset of terrorist communications is ultimately contained within the whole of the metadata produced, but can only be found after the production is aggregated and then queried using identifiers determined to be associated with the identified international terrorist organizations. The whole production is relevant to the ongoing investigation out of necessity. In addition to complying with 215, NSA's program must also comply with the Fourth Amendment of the Constitution. Here, the Supreme Court's decision in Smith v. Maryland is directly on point. In Smith, the court held that telephone users who convey information to phone companies for the purpose of routing their calls have no reasonable expectation of privacy in that information. Now, the Smith case is a number of years ago, and some have questioned the applicability of it because it didn't concern a situation where the government collected and retained the bulk metadata and aggregated it all in one place. However, a recent opinion of the FISA court addressed this specific issue, and it noted where one individual does not have a Fourth Amendment interest, grouping together a large number of similarly situated individuals cannot result in the Fourth Amendment interest springing into existence. I understand that there is interest in legislating reforms to the 215 program and other aspects of FISA, including the nature of the court process itself. We welcome this public debate and this public discussion about whether the current version of 215 and other provisions of FISA strike the right balance between our national security and the privacy of our citizens, both of which are important and have to be honored. We look forward to working with the committee to address these issues and to find the right balance. Thank you, Mr. Chairman.
Thank you very much, Mr. Cole. And our last witness on this panel will be Robert Litt, confirmed by the Senate in 2009 to serve as General Counsel of the Office of the Director of National Intelligence. Prior to joining the ODNI, he was a partner with the law firm Arnold Porter, worked at the Department of Justice, has testified before this committee before. Welcome back, Mr. Litt.
Thank you, Mr. Chairman, Ranking Member Grassley, members of the subcommittee. We do appreciate the opportunity to appear today to continue our discussions about the intelligence activities that are conducted pursuant to the Foreign Intelligence Surveillance Act. It's critical to assume that the public dialogue on this topic is grounded in fact rather than in misconceptions. And we therefore understand the importance of helping the public to understand how the intelligence community actually uses the legal authorities provided by Congress to gather foreign intelligence, and the extent to which there is vigorous oversight of those activities to ensure that they comply with the law. As you know, the President directed the intelligence community to make as much information as possible available about certain intelligence programs that were the subject of unauthorized disclosure, consistent with protecting national security and sensitive sources and methods. Since that time, the Director of National Intelligence has declassified and released thousands of pages of documents about these programs, including court orders and a variety of other documents. We're continuing to do so. These documents demonstrate both that the programs were authorized by law and that they were subject to vigorous oversight, as General Alexander said, by all three branches of government. It's important to emphasize that this information was properly classified. It's been declassified only because, in the present circumstances, the public interest in declassification outweighs the national security concerns that originally prompted classification. In addition to declassifying documents, we've taken significant steps to allow the public to understand the extent to which we use the authorities in FISA going forward. Specifically, as we described in more detail in the written statement that we submitted for the record, the government will release on an annual basis the total number of orders issued under various FISA authorities and the total number of targets affected by those orders. Moreover, we recognize that it's important for companies to be able to reassure their customers about how often, or more precisely, how rarely, the companies provide information to the government. And so we've agreed to allow the companies to report the total number of law enforcement and national security legal demands they receive each year and the number of accounts affected by those orders. We believe that these steps strike the proper balance between providing the public relevant information about the use of these legal authorities while at the same time protecting important collection capabilities. A number of bills that have been introduced in Congress, including the USA Freedom Act, which you've sponsored, Mr. Chairman, contain provisions that would require or authorize additional disclosures. We share the goals that these laws and bills provide of providing the public with greater insight into the government's use of FISA authorities. However, we are concerned that some of the specific proposals raise significant practical or operational concerns. In particular, we need to make sure that any disclosures are operationally feasible with a reasonable degree of effort and that they would provide meaningful information to the public. We also need to make sure that the disclosures do not compromise significant intelligence collection capabilities by providing our adversaries information that they can use to avoid surveillance. But, Mr. Chairman, I do want to emphasize our commitment to work with this committee and others to ensure the maximum possible transparency about our intelligence activities consistent with national security. We're open to considering any proposals so long as they are feasible and do not compromise our ability to collect the information we need to protect our nation and its allies. And we've been in discussion with the staff of this committee and the Intelligence Committee on some proposals and some alternate means of trying to provide greater transparency while protecting our critical sources and methods. We look forward to continuing to work with you in this regard. Thank you.
Thank you, Mr. Lloyd. Senator Grassley, normally I'd ask questions at this point, but I'm going to yield first to Senator Grassley, who does want to make the other briefing. So, Senator Grassley.
Yeah, hey, and I appreciate very much that accommodation. Mr. Cole, back on October the 2nd, I wrote a letter to the Assistant Attorney, or to the Attorney General, requesting information about cases of willful and intentional abuse of authority by NSA employees. Some of them were referred to the Justice Department for prosecution. I'd like to know whether these cases were prosecuted, and if not, why not? I asked for a response by December the 1st. Do you know the answers to these questions? And if not, when would I be able to expect an answer?
I don't know the specific answers on each of the ones you cited, Senator Grassley, but we're in the process of collecting that information. A number of them were not prosecuted. A number of them involved the risk of further damaging the national security by having to release more information. Other sanctions were found that were adequate in those cases, but we're trying to put together that information so that we can give you an assessment of what happened in those cases.
And I thank you for that courtesy. Mr. Cole, I want to make sure that I understand the administration's positions on the USA Freedom Act. In your prepared testimony, that bill isn't specifically mentioned, but in your testimony you state that the administration, quote, does not support legislation that would have the effect of ending the 215 program, end of quote, because the administration maintained that it is a lawful and valuable to protect national security. The answer may be obvious, but I want to be clear for the record. Do you understand the USA Freedom Act to be, quote, legislation that would have the effect of ending the Section 215 program, end of quote, that you described in your testimony?
Senator, you've kind of asked me a legal question, and I'm going to have to give you a bit of a lawyer's answer. It's going to depend on how the court, if the USA Freedom Act becomes law, it's going to depend on how the court interprets any number of the provisions that are in it and any number of the additional requirements that are contained in it over what's here now. I think it will have an impact on what is currently done under 215, but 215 covers more than just bulk data collection. It covers individualized business record acquisition. And depending on what kinds of records are being sought, what the facts and circumstances are, will depend on the nature and extent of the Freedom Act's impact on it. On the bulk data, I think it's going to be a question of the court's interpretation. Right now, the interpretation of the word relevant is a broad interpretation. Adding pertinent to a foreign agent or somebody in contact with a foreign agent could be another way of talking about relevance as it is right now. We'd have to see how broadly the court interprets that or how narrowly.
I appreciate your legal view. Just from a standpoint of how our process of legislation works, and since the President's Commander-in-Chief, the #1 person in charge of our national security, I would hope that we would have a firm statement from the administration of whether or not this legislation is harmful or not. and it'd be better to know that before courts get a decision, which would be years. Would be now, and I think that the administration owes that to all of us, both proponents and opponents, of what that situation is. Other than my other question to you as well, other than 215, the USA Freedom Act would also make other significant changes to the tools used to investigate terrorism and espionage cases. For example, the bill would raise the legal standard to issue national security letters to require that the information sought be both relevant and material, as well as the information pertained directly or indirectly to a foreign power or an agent of that power. This is a change from the current standard, which is mere relevance. Question: what operational effect, if any, will these changes have on the ability of your department and the FBI to protect the nation from terrorist attacks?
Senator Grassley, probably the largest effect that it would have on the NSL situation is the addition of the requirement that it be relevant to, or there is information that it is connected to, a foreign power. Many times NSLs are used in a very preliminary stage of an investigation in order to determine if the person who's being looked at is in fact a foreign power or an agent of a foreign power. And so the question is sometimes being answered through the use of national security letters. If you must answer that question before you can get a national security letter, it would reduce the availability of that tool in terrorism investigations.
Thank you, Mr. Chairman. And I have two questions that I'll submit for answering right. Can I answer one more? Mr. Litt, one of the issues this committee has been looking at is whether or how to add more of an adversarial element in the FISA court process. The chairman invited a former FISA court judge to be a witness at our hearing in July. Judge James Card explained in his answers to questions for the record that he did, quote, not believe that having independent counsel review all government applications before the FISC would be necessary or desirable, end of quote. This appears to be an approach reflected in the legislation that was passed by the Senate Intelligence Committee. In contrast, as I understand it, the Freedom Act requires the government to provide every application to the advocate. Question: between the different advocate proposals in the U.S. Freedom Act and the Senate Intelligence Committee bill, which do you believe is a better approach to making the FISA court process more adversarial, and why?
So, Senator Grassley, since the Department of Justice is the agency that really conducts the litigation before the FISA court, I'm going to defer the answer to that to Deputy Attorney General Cole, although I will say that there has been a lot of interagency discussion about the appropriate approach there, which I think he can lay out.
Okay. Senator Grassley, as I think we've said on a number of occasions, we find that there is a use and a value to having an independent legal representative in the FISA court process in the appropriate circumstances. We would not advocate or recommend having one for all of the procedures that go on there. Many of them, like in normal criminal cases, are routinely done in an ex parte basis. They're done usually with a fair degree of expedience and efficiency, and we think a permanent public advocate might impede that process some if it's applying to every single thing that's there. There would also be, I think, some constitutional issues of standing for a public advocate on every single issue. We would propose that it be an amicus appointed by the court when the court feels that they have the need for another perspective and another point of view, when it's a significant issue involving privacy issues, civil liberty issues that the court would like to have another view on. That would be a good example of a time. Something like the bulk data collection programs, where somebody may want to have a view of what the law is other than the government's view. We think that would be a good area. But I think the court's in the best position to determine when and where it's going to need those kinds of things and do it only for those issues.
General Alexander, it'll take you 5 seconds to answer this question. At our hearing in July, your deputy director testified that the NSA was conducting an investigation into how so highly classified information was compromised by a single contractor. He stated the NSA would report back to Congress about individual and systemic responsibilities of what occurred. When can we expect that report?
We'll send that up right away. We've actually taken 41 different actions, and we'll get you a report on what those are
What is right away?
over the next week.
Okay, so we'll have it by Wednesday.
Thank you, Mr. Chairman.
Next Wednesday.
By then. Thank you.
Thank you.
Thank you. On this last, the penultimate question about 215 phone records and FISA courts or FISC courts and so on, it's been said these have always been authorized. They've never been up on appeal. We've never had an appellate court rule on them. The bill that I have does not require an advocate in every FISA court case. It would be only when the court agreed that it might be helpful. We also have statements from judges that if that was the case, there might be more credibility with the courts, or at least more of a willingness on the part of the public to accept courts that operate in secret. Would you agree with that, Mr. Cole?
I think that would help the public have better confidence. I think the court does run well. I think there is a great deal of independence from my experience with the court in its rulings. It is not by any means a rubber stamp, but I think there's a value to the public to having some other person, some other advocate in the appropriate kinds of cases, and I think there's a value to that, Mr. Chairman. So I think that is a good idea, as long as we keep it in the right matters. So I would agree with that.
And Senator Klobuchar will submit her questions for the record, and I'd ask them to be answered as quickly as possible. Now, we get in these press accounts that the NSA is collecting billions of cell phone location records every day, and is reportedly gathering information or communications information from online gaming sites. The stories suggest the activities are directed abroad. We know the NSA was making plans to obtain cell site location information under Section 215. We also know that the NSA engaged in bulk collection of Internet metadata under the FISA pen register statute. So it suggests to me that under that kind of a legal interpretation of FISA, the NSA could collect the same massive amounts of information domestically that these recent stories suggest they are collecting abroad. So, Mr. Litt, maybe I should direct it first at you. I know the program authorizing bulk collection of email and other Internet metadata was shut down in 2011 because it wasn't operationally useful. But under the current law, would the NSA be able to restart the bulk collection of Internet data?
I think that if the NSA and the Department of Justice were able to make a showing to the FISA court that the collection of Internet metadata in bulk, which of course is a category of information that's not protected by the Fourth Amendment, that if it were relevant to an authorized investigation and could convince the FISA court of that, then yes, it would be authorized.
It was shut down before as not being operationally useful. Would you have to go to the court?
I believe we would have
to restart the bulk collection of Internet data. Would you have to go to the court?
I believe we would.
Mr. Cole?
Yes, Mr. Chairman. Under the FISA statute, I think you would have to get court authority, just like you would under 215, to be able to do that, and that would only last for a period of time and have to be renewed periodically. So there's no active authority for it right now.
And setting aside any technological limitations, would the FISA pen register statute authorize you to obtain all Internet metadata, not just email metadata?
I think that is correct, but again, it would be limited to the metadata in that regard.
So,
and if I could just add on that.
If I could just make sure I understand Mr. Cole's answer. So the only limitation would be that it'd be metadata.
It cannot be content. It cannot be any. And in the latest order of the FISA court under 215, it specifically excluded cell site location as well.
I was going to add only that you'd have to show that the categories of metadata that you're seeking was in fact relevant to the authorized investigation.
Okay, well, Mr. Cole, you talked about the legislation that Senator Lee and I talked about to update the Electronic Communications Privacy Act. We want to inquire in criminal matters. I'm talking about just criminal matters now. The government obtain a probable cause warrant to gain access to the contents of electronic communications that is stored by a third-party provider. Section 215 of the USA Patriot Act requires the government to show only relevance to an authorized intelligence investigation in order to obtain records. I'm not talking about bulk collection, but the more standard usage of 215. Has Section 215 ever been relied upon to obtain the contents of stored communications from a third-party provider?
Not that I am aware of, Mr. Chairman.
Mr. Litt?
I'm hesitant to give an answer to that just because it's not a question I've ever asked. I'd prefer to get back to you on that, sir. I just don't know the answer sitting here.
Can you get back to me by the end of the week?
I will try.
If they haven't, as a legal matter, could Section 215 be used to obtain the contents of communication?
I would have to think about that, considering that it's limited to the types of information you can get with a grand jury subpoena. I'd have to look, because of the aspects of stored communications and things of that nature, I'd have to check, but I'm not sure. I'd have to go back and look at that. So without a check of the legal authorities, I'll get back to you on that, Mr. Chairman.
Yeah, and I appreciate you checking those. I think you understand by the question.
Yes,
There are some serious legal ramifications to your answer.
I agree.
Well, good. And I'm going to yield to Senator Franken, but General Alexander, you talked about using, and I'll get to you in my next round, about going to the private sector, looking for best practices from them. As you can imagine, I'm going to ask if those best practices had been used, would a 29-year-old subcontractor been able to walk away with all your secrets like Mr. Snowden did? Senator Franken?
You're going to ask that in the next round?
Sure, but you...
Do you want to answer it now? I mean...
You don't, no, that's okay. Well, I don't want to take... You've been waiting patiently. I'll wait my turn.
Well, okay. Well, generally, you'll have plenty of time to think about that. Except I have a question for you, so we'll see if you can do both at the same time. I have a bill, too, called the Surveillance Transparency Act that I think you're all familiar with. Among other things, General Alexander, the bill would require NSA to tell the American people how many of them have had their communications collected by the NSA. Do you think that the American people have the right to know roughly how many of them have had their information collected by the NSA?
I do, Senator. I think the issue is, how do you describe that? Those that are under a court order, so under FISA, as you know, to collect the content of a communications, we have to get a warrant. The issue would be almost in the Title III court. You tell someone, a U.S. person, who may not be a U.S. citizen, that we're tracking them here in the United States, or that we have identified that.
I'm not suggesting that you have to tell people they're being surveilled, I mean, that they personally are a suspect. What I'm saying is the American people have a right to know how many American people have had their information collected. That's a different question. I wasn't suggesting we tip people off that are suspects.
Yeah, so I think in broad terms, absolutely. And let me give you an example.
In broad terms.
Yeah, so for example, under 215 today, less than 200 numbers are approved for reasonable articulable suspicion for being searched in that database.
200
numbers.
People. That's 200 orders or 200 people?
200 numbers. Some of those numbers may be multiple numbers per person. Those numbers could be both foreign and domestic. In fact, they are. But that's the total number for that category for Section 215 today under that program. The other one that I think, and I think the Deputy Attorney General mentioned, is we can also put out more about what we're doing under the FAA 702 program that we've compelled industry to do in a more transparent manner. The issue is, how do we do that without revealing some of our own capabilities? And we're working through the interagency to get resolution on that. Say that right?
Okay, I'm being told by staff that that's actually a number of people have had their phone numbers searched, not collected.
So,
Right.
so under 215, all the data is going into a repository.
Metadata.
Metadata. So if, for example, I'm talking to a foreign terrorist, my number would automatically hit that link. In fact, you probably would want to know that. I know
Right.
the White House would.
We need to know that.
That's right. So the issue would be how many of those. What we would do is we'd look at those and, based on our analysis, give those numbers that are appropriate to the FBI for them to then go through their appropriate process to look at those numbers.
Okay, there's a difference between collected and searched, but that's okay. But let's talk about 702, okay? That's supposed to target non-Americans, right? Foreign persons.
Reasonably believed to be outside the United States.
Right. Are Americans, shouldn't the American people know how many of Americans have gotten caught up in that?
That, again, is, and I don't mean to hedge, let me just tell you the difficulties that if a terrorist that we're going after is talking to another person, in that communication, there's nothing that says, I'm an American, and here's my, my Social Security number. So the fact is, when we're tracking a terrorist, if they're talking to 5 people, and one of those is American, chances of us knowing that are very small. If we find out that's an American, then there are procedures that the Attorney General and the courts have given us that we have to do to minimize that data on that American.
Okay, well, I guess my question is that my bill calls for the NSA to report how many Americans' information has been searched, has been looked at by agents. Mm-hmm. And I'm not talking about necessarily a precise number, but 702 says that it can only look at non-Americans. And my feeling is this, is that the American people are skeptical of executive power.
Right.
That when there is a lack of transparency, they tend to suspect that they tend to be very skeptical and suspect abuse. And part of the reason to have transparency is for people to be able to make their decisions based on some real information about whether or not this power is being abused or not. Now, I believe that you gentlemen have our national security at interest. That's your interest. That is your interest. But I also believe that, you keep saying there's oversight from all 3 branches of government. We're one of the branches, and we're doing the oversight, okay?
We're feeling it.
And my feeling in doing the oversight is that I would be more comfortable and that the American people would be more comfortable and feel that they can decide for themselves if they knew how many Americans were being caught up in a program like 702 that is designed by law not to target Americans.
So I think, Senator, absolutely, but I would just put into this that what we're going to do is, if asked to do that, we're going to give you faithfully and truthfully that which we know. And my concern would be 2 days later we find out that was also an American. So we could report that later, but we're not going to, do you see what I mean?
Wait, no, because what I'm talking about in my legislation isn't a precise number.
It's a number.
It's a range.
Yeah.
And what I've been told by ODNI is that producing this estimate would be very difficult, but I don't think it would be that difficult.
So it may be. I would just offer, Senator, to have you come up, and we could sit down with, and show you this, and then come up with perhaps a way to do that. Because I do think, actually, I agree with you. I think this is the right thing to do because the number isn't that big. And I think if we could explain it to the American people, and you, as one of our three elements of our government, could say, here's what we see, and here's what the administration sees, and here's what the courts, and all three of us together say, that's the best number we can come up with. When you see that, when the American people understand that, they'll know we're doing this right. So I agree with you.
I see Mr. Litt, who I know quite well, we've discussed this a lot, sort of jumping out of his seat.
No, I'm firmly planted, sir.
Okay, no, well, eager to answer, and that's why I'm afraid I've run out. No, I'm sorry. Go ahead. Go ahead. I see that you're. I've never seen him this eager, frankly.
Mr. Chairman, if I might for a minute, I think this is a good example of the kind of thing I was talking about in my opening remarks. I think we all agree that the question you pose is a reasonable one, which is how many Americans are being caught up in this. The problem is trying to find a way to provide that information in a manner that's both operationally feasible and doesn't compromise sources and methods. We've got some ideas in that regard. They're not fully fleshed out yet. We do want to work with your staff and see if there are ways we can arrive at something that will, give at least some sort of reasonable proxy that gives Americans an idea of what the impact of this surveillance is.
Thank you. I'm glad I've got this answer today because this has been part of my discussions with Odie and I, where you've said that this may be too difficult to do, but it sounds like we've got a little bit of movement on this. I wanted to ask a question about what you were referring to, Mr. Chairman, about location information, but I really am way over my time. Thank you, for your indulgence. This is on the capacity issue. General Alexander, in a hearing, let me go beyond that. Last week, the Washington Post asked an intelligence official speaking on the record to estimate how many Americans had had their location information collected by the NSA. The official answered, quote, "It's awkward for us to try to provide any specific numbers." Right after he said that, the article says that an NSA spokesman interrupted the conversation to change that answer. Do you believe it's difficult for this to estimate how many Americans have had their information collected, or do you think it's awkward?
I think it's difficult, but I think we're talking by each other, if I might explain.
Okay, good.
Under the business record FISA, there was a series of questions on cell site location information that Senators Wyden and others had asked, and we have walked down that road. As you know, that's one that the court said, we're not doing that, we don't do that. There has been a few records that were done to check to see if technically it could be done. That was the first set of issues on the business record FISA. So there is no cell site location data under business record FISA that we're using today, period. Second, if an American travels overseas and its communications are collected, the chances are in that collection, we may not know that that's been collected, that it was an American person, but the chances are if you collect A, you will probably get the cell site location with that because that's something that's also collected. The issue would be how many of those have been collected, and the answer is we're really not looking for that. It may have been collected because they talked to, as we use, and I don't mean any of these people are bad, I'm just using this security. Well,
You seem to point to them a lot.
I just want you to be careful because they're right behind you. But I am concerned, Senator, that in that case, we won't know at all who are the Americans and who aren't in those issues for the same reason before. But what we can tell you is, I think, good numbers on those that we target overseas that are Americans under those procedures that we have. We can give you those numbers, 703, 4, and 5, that fall into that. And I think that's perhaps what we're really looking for. Does that make sense?
Yes, well, thank you. And Mr. Chairman, thank you for your indulgence. I also want to go down to the briefing. Thank you, gentlemen.
Say hello to everybody for me. General, go back to the question I asked, and not facetiously, I assure you. When you said that you work with private industry on proving techniques and so forth, and I assume you would. Let's go back to the Snowden case. As you know, I've expressed grave concerns about how a 29-year-old subcontractor can come walking in, and that your system of checks and balances and all was not good enough to stop him from walking out with a huge amount of data. I see something similar, all the different type of data, when our own State Department and Department of Defense put huge numbers of highly classified and highly sensitive cable traffic from some of our embassies into one location where a private first class, I believe it was able to go in and take it all out on a Lady Gaga CD. And we know the enormous problems caused to our diplomacy and the security of a lot of Americans and our allies because of that situation. And never found anybody to say what we ever gained by putting all that material in one place. So now we go to the Snowden case. Whether somebody thinks he's a hero or a villain is not so much the question as it is, I think we can all agree, that a lot of the material that has been released because of him has been very damaging to the United States. It has certainly been damaging to our allies, our relationships with our allies. I realize, as you and others do, that some of our allies who have said how terrible it is we're doing this has to make one think of the scene in the movie Casablanca. I'm shocked to see this going on, knowing that they're doing very similar things. But having said that, there were things that created grave problems for us. So my question is, first, and can you say with confidence that you now have checks and balances at NSA to stop something like this happening again? And secondly, has anybody been disciplined at NSA for dropping the ball so badly?
So first, Chairman, on the checks and balances and the things that we've done, that's the 41 different actions that I discussed for Senator Grassley that our technology directorate is using. That does employ best industry and best practices that we have, and has drastically improved that capability.
These were subsequent to the Snowden
That's
theft.
correct. This is all since the Snowden thing. This gets into compartmentalizing and encrypting data to creating communities of interest. And we do have 3 cases that we are currently reviewing, working our way through, that I don't want to prejudge, given my position, that we will fully inform this committee of action that we've taken once that action is complete. So we are doing that.
Now, first off, whether it's 41 steps or 35 or whatever, I would hope that this makes it better. The obvious question comes up: why weren't these steps taken before? Was it because there is a sense of confidence that we are the NSA, we will not make a mistake? Or was it just, well,
actually, Chairman, the reason it happened is his job was to move data. He was the person who was to move the books from point A to point B. He was the SharePoint server, web server administrator. His job was, in fact, to do what he did. And therein lies part of the problem. We had one individual who has a responsibility to move that data who betrayed that trust. We believe that they would execute that duty faithfully and in a manner that everybody had agreed should be done.
Well, to use your analogy, General, let us say I run a company that sells millions of dollars worth of diamonds. And I'm going to have to transfer them from my warehouse in this state to my warehouse in this state. Now, am I negligent if I say, well, look, we got this 29-year-old subcontractor, here's the keys to the car, the truck that carries all these diamonds, get them there safely, by the way, here's a map? Or is it better off that I have 2 or 3 people who check on how it gets there?
So prior to this event, it was standard that one person would do one job and he'd have backup help and you'd have oversight of that. But in doing that job, it's very difficult, if not impossible, to see that that person replicates a copy of what he took. A little bit different than in the diamond case, but your point is well taken. You wouldn't give the guy the keys to the car to drive your diamonds across state, especially when you didn't know them. In this case, what we've done is we've input a 2-person rule, just like you would for that, for these specific issues, and you'll see that in parts of the write-up. I would also point out, one of the notes I got is from the WikiLeaks, we were already implementing the WikiLeaks issues that had been found through the interagency process. So we were implementing that. This specific vulnerability that he exploited was not found in the WikiLeaks area. And there were some specific things that I prefer not to go into here because...
Can I suggest that there's still going to be people out there going to want to find more things? Will we both agree on that?
Absolutely.
And can we also agree that the vast majority of people who work with you, and I do believe this, are very honest and would not want to do anything to betray the country they serve? Is that correct?
Absolutely, Chairman.
Thank you. We talked about the legal standard for bulk collection programs. And that is one thing. The other thing is, do we really need to be collecting massive amounts of data on innocent Americans to keep us safe? I mean, just simply because you can do something, does it make sense to do it? We had a question, an entirely different matter before this committee once when I'd raised the question about roadblocks being set up by our border people in Vermont on one of our interstate highways about 40 or 50 miles from the Canadian border. And they said with great enthusiasm that, well, over a period of X amount of time, they found 4 or 5 illegal immigrants and collected X amount of marijuana and some cocaine. I said, wonderful. As they spent a huge amount of money and set up this roadblock, inconveniencing everybody. I said, look how much more you could collect if we set up those roadblocks on every single bridge coming into Washington, D.C. in the morning. A couple 100,000, 100,000, 200,000 people come in from Maryland, same number from Virginia and West Virginia, unless we have something, a cataclysmic thing like 2 inches of snow, and then of course we have to close. Vermont, anything under 5 inches of snow is called a dusting, but I digress. But the fact is, but not much, the fact is, if we set those kind of roadblocks, we'd collect hundreds of illegal immigrants. We would collect huge amounts of illegal drugs and probably other contraband. Would we do it? No. I mean, the place would come to a screaming halt, and there would be those people who are totally innocent and all who might be screaming about it, including chairs of various oversight committees. But my point is, we've already established that Section 215 phone records collection program was uniquely valuable in just one terrorism-related case, not the 54 that have been talked about before. The NSA shut down a bulk collection program related to internet metadata because it wasn't meeting operational expectations. And I was concerned to learn NSA has never done an assessment of the effectiveness of about collection under Section 702, despite the fact the program mistakenly led to the warrantless collection of thousands of domestic emails, including their contents. We can do a huge amount, but then at some point you have to ask, what do we get out of it? So, General, I'd ask you this. Shouldn't the NSA assess the utility of its various collection methods in a systematic way, especially if they pose a risk of obtaining Americans' communications? I mean, the question would be very simple if we were talking about going into everybody's home to look at their letters or their files or their those personal things. But somehow we're looking at it differently because it's out there electronically.
Senator Chairman, that was exactly why under the pen register trap and trace, the email metadata program, when we looked at that, and I was the key NSA official to say, this program does not meet the operational requirements for the amount that we're putting in, and we recommended to the DNI and the White House that we stop that and inform Congress. So we made that operational decision based on what we got for what we put into it to what it cost us. We did the same. We're doing the same on the business records, FISA, the metadata program. And we looked at that. Here's the issue that, quite candidly, that I'm wrestling.
You're doing that now in the PRTT?
We did the PRTT back in 2011 when we stopped that program. And that was based on my recommendation, based on working with our people to look at what we're doing.
Did you find any terrorism plots that helped thwart?
With the pen register trap and trace, I'll have to go back and get you the specifics on that. That'll take more than Wednesday, though. But I will get you that answer.
Okay, because I'm thinking when Deputy Director Inglis testified, there was only one time where Section 215.
Right, so that's section. So now we're going to 215.
But
the issue that I have on 215 and why I am so concerned, I agree that what Congress, the courts, and the administration have given us here is extremely intrusive, taken in its whole. But the way we've put the oversight and compliance and the regimen that we have around it and the oversight by the courts, the administration, and Congress ensure that we're doing this right. And the frequency that we look at that, less than 200 numbers now approved, and less than 300 for all of 2012, from my perspective, that shows that we're being judicious in how we do it. There is oversight by all three branches of the government and complete auditability on every action that we do. We don't have a better way of doing this. So that goes into that question of industry. So my question is, I don't know a better way to do it. And I'm being completely candid. I am concerned with all that our country is going to face, that we will have failed the nation if an attack gets through. And so you've asked us to do that. I can't think of a better way. I think this is where industry, do they have a better way of doing it? We ought to put it on the table and argue that through all branches of the government. Nobody has come up with a better way. And so that's my concern with the metadata program that we have today. I can't think of a better way. It's like holding on to a hornet's nest. You know, we're getting stung. You've asked us to do this for the good of the nation, to defend the nation, to get the intelligence we need. Nobody's come up with a better way. If we let this down, I think we'll have let the nation down.
Well,
so that's why I'm concerned.
General, I realize the world changes, but I think back to my days as a young prosecutor, and without going into war stories, I remember when, as a member of the executive board of the National DA's Association, we had a meeting with J. Edgar Hoover. And 4 or 5 of us there, we went across the spectrum politically. We were all chilled by what we heard from him, his disregard of the Constitution, his willingness to do things. He explained to us there's no such thing as organized crime, in America, even though, of course, there was a massive organized crime operation at that time, but we had to fear communists. They even suggested to us that the New York Times, in its editorial policy, was very close to becoming a communist newspaper, and he was about to investigate it as such. I'm serious. I'm always thinking what would have been like if he had had the power that you and the NSA had. And that's, I had a friend who died in the towers, 9/11. I think about that all the time. I think of my wife, who was a medical surgical nurse at Arlington Hospital, going there, even though she'd retired, to volunteer to help with the wounded coming from the Pentagon, and told there were no wounded. You were either alive and walking or you were dead. There's nothing in between. These things sear in your mind. You don't want this to ever happen again. But I also think of the J. Edgar Hoover type thing. And I think as an American, it's very easy to go to another country and complain to them about their police state. I'm not suggesting that's what you are, but their ability to go and listen in on everybody, search everybody. We give up a lot of our privacy in this country. And frankly, I worry about giving up too much. And can we be totally secure? Of course we cannot. You can't be totally secure going out to dinner in the evening from some random shooter who isn't even aiming for you. So, I mean, I look at the administration declassified a number of FISA court opinions, and they get credit for doing that, but there's been no release of any FISA court opinion from the 2006 time period containing legal and constitutional analysis of the Section 215 phone records program. I don't know, is that because it didn't exist or hasn't been declassified? And I asked this question, and I'll let Mr. Cole give me an answer to that at some appropriate point, but that I really feel that our oversight has not been adequate, or that so much of it is done secretly that it's too easy to say, if you knew what we knew, you wouldn't ask us questions. And I worry as technology gets greater and greater, the temptation, whether it's this administration, or the next administration, or the administration after that, to people to misuse it. So I know I've been critical of these things. I hope none of you take it personally. But as a Vermonter, I'm very concerned about my privacy and everybody else's. Did you want to add anything, Mr. Cole or Mr. Litt or General?
Mr. Chairman, I think that we are all concerned to make sure that we get this balance right, and that an important part of that balance is transparency to the American public, keeping their trust in what we're doing, making sure that while doing that, we don't compromise our abilities to be able to use classified techniques that will help keep them safe. But there's a tension between those two. And there always has been, and finding that right balance is always something that is difficult, but it is our job. And it is our collective job in all three branches of government, including with oversight from the United States Congress, as a very important part of that. So I think the path that we are on now is very much the one that you're describing, of trying to make sure that we find that line and find that balance of giving the information that we can give, providing the transparency while maintaining the operational integrity of what we're doing. We shouldn't be saying to you, particularly from an oversight function, if you only knew what we knew, you would say we're doing fine. We should be in a position to be able to tell you what we're doing.
Mr. Chairman, if I can just add a couple of points there. The first is that, as I'm sure you know, there's nobody in the intelligence community today who operates on the assumption that you ascribed to J. Edgar Hoover before, that I don't care what the Constitution says. Everybody is singularly focused on ensuring that we comply with the Constitution and the law. And as you know, in all the material that's come out, there's been no suggestion of any willful abuse or violation of privacy of people. The compliance violations that have occurred have been technical, they've been unintentional, but nobody's been out there attempting to illegally spy on Americans or anything else. But the other point I want to make is sort of a more philosophical one, because the point you raise about worrying about the next person is, of course, something that was a concern all the way back to the framers of the Constitution, which is why they set up the Constitution with checks and balances to try to ensure that the innate tendency of human beings with power to seek to abuse that power is checked. And that's what we've tried to accomplish within the intelligence community with the degree of oversight that we have, the number of people who are looking over other people's shoulders, the number of reports that have to be done, the technological controls that we have in place. As General Alexander said earlier, if there are ways we can do that better, we're open to that. We'd like to ensure that there's oversight that is sufficient to persuade the American people that we are doing the right thing in their behalf. But we do think it's important that that in considering what to do, we don't throw out the baby of national security with the bathwater of oversight.
Well, and if there are better ways of doing things, if there is any silver lining in the Snowden matter, you are taking, I understand from General Alexander's testimony, you are taking the steps to make sure that colossal mistake wouldn't happen again.
We're going to do our best.
General?
Chairman.
And then after you speak, General, I'm going to turn the gavel over to Senator Whitehouse, because
I have a lengthy response.
He's a nicer person than I am. Go ahead.
Chairman, first, two things. As you correctly stated, there was one unique case under 215 where the metadata helped. There were 7 other where it contributed, and 4 where it didn't find anything of value, and we were able to tell the FBI that. Now, that last part of value, I want to point that out. This summer, there was a big issue on terrorism that we all went through. This program actually helped us understand, was that focused on the United States or elsewhere? We used that program to determine none of those leads were coming into this country, and we're able to focus our efforts elsewhere, which really helped both the intelligence community and the FBI in that case. The second part, you know, I've been in this job for a little over 8 years, and my experience from dealing with the people that we have, dealing with Congress, the courts, and the administration on this, is our folks take the Constitution to heart. We see this as 2 roles: defend the nation and protect our civil liberties and privacy. Everybody at NSA, including myself, takes an oath to that Constitution that will support and defend the Constitution, and you know the rest of that. And I would tell you that the oversight we have, especially by the courts, ensures that what happened that you brought up will not happen here. From my perspective, we have great oversight in this program. And at times, I complained that the oversight was so robust that it was crippling, but now you can see that everything that we've done, all the things that have come out, were either self-reported or brought out. They weren't revealed by Snowden. We had already reported those incidents. I think you can see that we're acting well and faithfully to discharge those duties. Just to correct one thing to add to what Bob said, there have been no willful or intentional violations under the 215 or 702. As you do know, there were 12 under Executive Order 12333. In both cases, all the violations that we know about, we've self-reported. Some of those we knew would be significant. We brought them up to the White House, to the DNI, to the Department of Justice, to the courts, and to Congress. We made a mistake. These were not intentional. They were significant, and you've read the court things, and you read some of those. But from my perspective, I think what we should take great pride in the fact is this agency, in every case, reports on itself, tells you what it did wrong, and does everything we can to correct it.
Thank you. So the White House, why don't you take here, and I apologize to the next panel that I may not be able to get back. I'm going to try to, you want to take the seat here?
Sure, I'll do that when the panels shift. But let me just take a little bit of time myself right now with this panel before they're excused. First of all, we are at a time
where we have entered a new technological era, the era of big data. And I'll loosely and unprofessionally define big data as the ability to aggregate enormous amounts of information that don't get looked at, and then figure out ways, once they're aggregated, to search for things in that big heap of data. And that raises questions about whether the aggregation is a search or whether it's not a search until a human being actually asks a question and actually the information gets to another human mind. And some of these are pretty difficult questions that we have to work our way through. And so I think the attention that the committee is paying to this is a very sensible attention. But our national intelligence establishment is not the only group that is playing in this big data area. We all know that Google and other private sector providers are very, very actively in big data, data mining, and doing things like that. What can you tell me about what other governments are doing without specifying names and releasing any national security information? I take it that other foreign sovereigns are doing very aggressive things in this space to try to pull as much information as they can as well out of the cloud and out of the capacities of big data. Who'd like to take that? General?
Senator, I have some experience in that. My opinion, none of them have the oversight by all three branches like we do, either their parliaments, Congress, their courts, and their administration.
Understood, but my point is that they're all out there doing it.
They do.
And that if we were to, the ones that have the capability, the most powerful ones all do.
That's right.
And if we were to pass a law that prevented our intelligence and defense establishment from operating in that big data atmosphere, we would be essentially unilaterally disarming in an arena in which other governments are very active. Is that true?
That's true. In fact, I think some have likened it to, because we have a powerful intel community or powerful Navy, we would tell our submarines to surface in those areas where their subs aren't as good.
So they're, and the actual collection of data in the sense that it is brought to the awareness of a human mind somewhere has to be overseen very scrupulously. And as I understand it, this operation is overseen by multiple inspectors general, multiple general counsels, multiple federal executive agencies. NSA connects in ways that provide varying levels of visibility, but in most cases, complete visibility to our Department of Defense, to the FBI, to the Department of Justice, Jim, to the ODNI, the Office of the Director of National Intelligence, to the President, to the National Security Council. So there's considerable attention that is being dedicated to this. We have a court that is dedicated to this that reports to the Supreme Court. We have this legislative committee, the Senate Intelligence Committee, and the House committees. So it's hard for me to think of whatever we might do to add to the level of oversight. I think we may make it more efficient and effective, but I don't want anybody to leave this hearing thinking that we kind of just leave this question to the NSA. We have built a system in which every branch of government, and within those branches of government, in many cases, multiple different agencies, and in some cases within those agencies, multiple different, and in some cases, independent sectors all compete to have a look and to make sure that the right things are being done. So I'll let you all go. I appreciate what you're doing. I understand that we need to get this right, but I think it would be a mistake to unilaterally walk away from the realm of big data to protect our national security when we're perfectly comfortable with private companies doing that to make money and to find out more about us so they can market to us better, and when foreign governments are energetically penetrating this space in order to accomplish similar results. And I think nobody should leave this hearing not aware that the layers of oversight and checking and double checking and triple checking that are done here are very, very rigorous and considerable. I know you have to live with that all the time. If you'd like to make any closing comment to that, I'll let you do that, but otherwise I'll let you go.
I think you've summarized it very well, Senator.
All right. Well, we'll leave it with that, and I appreciate very much you all being here. Thank you for your service to our country.
Thank you, Senator.
And we'll take a minute and call up the next panel. It was hard to get Bob Litt out of here, Professor. He loves it so much being in front of us. All right, let me ask the panel to stand to be sworn. Do you affirm that the testimony you're about to give to this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. Please be seated. I am delighted to welcome our second panel on this important issue, and why don't I just go right across the table and ask each of you to make your opening statements, and we'll do collective questions at the end. We may be rejoined by a number of my colleagues. This is the time that the administration briefing on Iran is taking place in the classified area, and so obviously that's of interest. We'll start with Ed Black, who has been the president and CEO of the Computer and Communications Industry Association since 1995. He previously served as chairman of the State Department's Advisory Committee on International Communications and Information Policy, and he worked as chief of staff and legislative director for 2 members of Congress. Mr. Black, welcome. Please proceed.
Thank you, Senator Whitehouse. It's a pleasure to be here. Thank you, members. Thank you very much for the opportunity to be here. Thank you, Senator Whitehouse. This is an important subject. I want to start out by just pointing out that 16 years ago, the White House charted a course for a vibrant Internet economy in the Perceptive Magazine report, the first U.S. government policy statement addressing the needs of Internet commerce. That policy statement correctly identified user trust as the foundation of Internet commerce. It noted, quote, "If Internet users do not have confidence that their communications and data are safe from unauthorized access or modification, they will be unlikely to use the Internet on a routine basis for commerce." That may sound rudimentary today, but we should not take for granted decades of progress in creating security and fostering user trust, and we should not discount how easily that foundation can be damaged. The broad NSA surveillance regime and the way it has been received internationally has harmed U.S. companies, U.S. competitiveness, and the Internet itself. The U.S. government must be proactive in addressing these concerns. The status quo is no longer an option. If we do not act, we will put at risk our economic security and undercut our diplomatic ability to influence the future of the Internet. Therefore, Mr. Chairman, CCA supports the USA Freedom Act, and we look forward to working with the committee and staff on this important piece of legislation. A healthy global internet is a source of American competitive advantage. The U.S. ITC has documented a growing digital trade surplus. Our global competitiveness is not just good for commerce, it is an essential component of our long-term national security. The Internet doesn't only benefit the U.S., however. The open Internet provides great global commercial benefits. The Internet economy in G20 countries is expected to reach $4.2 trillion by 2016. Estimates show that 21% of economic growth in mature economies over the past 5 years is attributable to the Internet. Traditional industries are the beneficiary of 75% of the economic value derived from the Internet. Thus, we should not underestimate the Internet's role in global economic development, which in turn has its own security benefits for the United States and the rest of the world. The NSA's practices clearly impact the business of U.S. Internet companies. So much of online commerce today is fundamentally based on trust. If users are going to turn over very sensitive, personal, and confidential information to a company providing online email or other cloud services, they need to believe that the company will act as a responsible steward of their data. Although traditional debate on the utility of overbroad NSA surveillance has focused on hard power arguments, one must not overlook the effect on soft power. It is important to recognize the dramatic effect these revelations have had on our international and diplomatic authority, particularly in regard to the future of Internet governance. Last year's WICIT conference showed us that there is deep international division over whether to subordinate the open Internet to the political machinations of world governments, including repressive regimes. The U.S. needs to be a beacon for freedom and openness in this battle. Given these risks, we propose enhanced transparency and procedure reform, clearer protection for Americans, and baseline protections for international users. With regard to transparency and procedure reform, we think all governments should share with citizens meaningful information about their surveillance laws, their legal interpretations, and the judicial procedures that govern the exercise of this powerful authority. Of course, the U.S. cannot demand this from others unless it leads by example. Furthermore, companies should be permitted to disclose publicly to their users the precise volumes of requests from governments. Businesses should not only be permitted to release transparency reports, but encouraged to do so. We categorically reject the notion that open government will cause undue damage to security. Transparency in criminal surveillance has been the norm for years and does not appear to have materially affected law enforcement. In order to present a robust check on the government, the FISC must also evolve to conclude a committed and well-resourced advocate to provide an alternative viewpoint, particularly in situations involving novel questions of law. Second, focusing on protection for Americans. Federal laws addressing the circumstances in which the government may collect American data for national security purposes are badly in need of reform. Bulk collection of metadata is one area where that is most obvious, as it reveals a great deal of sensitive private information. Furthermore, important First Amendment rights of association are implicated by the government assembling its own version of your social network and their own analysis. The USA Freedom Act addresses this problem by explicitly prohibiting this type of bulk collection, both on the Internet and on telephone networks, and that is one of the reasons we are supporting it. Third, and finally, protections for foreigners. A difficult subject to deal with, but despite the global interconnected nature of the Internet, U.S. national security policy continues to presume U.S. citizens deserve protection from unwanted surveillance, while others do not. If foreigners lack baseline privacy assurances, foreign competitors will supplant U.S. leadership in Internet innovation and digital commerce, thus undermining strategic, economic, and other security interests. This is especially true going forward, as foreign markets are increasingly important. Thank you very much for the opportunity to testify. Look forward to your questions.
Thank you very much, Mr. Black. Our next witness is Julian Sanchez, who is currently a research fellow at the Cato Institute, focusing on the intersection of technology, privacy, and civil liberties, with a focus on national security and surveillance issues. He previously served as the Washington editor for a technology news site and has written for a wide array of publications. Mr. Sanchez, welcome.
Thank you, Senator Whitehouse. It is a privilege to address this committee. I want to begin by suggesting that if we step back from the details of the disclosures of recent months, we find a disturbing pattern across multiple programs and authorities emerges. I'll focus in particular on the telephony metadata program, the now defunct Internet Metadata Program under the Pen Trap Authority of the Patriot Act, and upstream collection under Section 702 of the FISA Amendments Act. In each of these cases, what we see is that extraordinary but nevertheless limited authorities were secretly interpreted in ways that permitted far more extensive collection that certainly members of the general public and even, I think, many legislators believed at the time of passage had been authorized. This was done in part because the FISA court, which was established on the premise that it would be authorizing and finding probable cause in cases of specific and traditional targeted surveillance, instead found itself in the position of addressing broad programs of surveillance, often involving novel legal or technological issues that it's not clear that body was well established to consider. In the metadata cases, these interpretations took the form of an unprecedented reading of relevance that held entire databases containing information about millions of admittedly innocent Americans to be relevant on the grounds that a fishing expedition through those records might ultimately turn up evidence that would not otherwise be detected in the absence of some specific grounds for suspicion. That is probably true, but it is, of course, true of any fishing expedition and defeats, I think, the purpose of the relevance requirement if that argument is allowed to go through. There is no real limiting principle in that argument for any type of records, and I was in particular disturbed to hear earlier Mr. Litt refuse to reassure us that the scope of the records obtainable under Section 215 does not exclude the contents of digital communications or cloud-stored documents. It's also particularly troubling to see this applied in the case of the Internet Metadata Program, because in that case, the, in my view, short-sighted holding of Smith versus Maryland was applied as though it referred to metadata generally, which is certainly not a term we find in the 1975 decision, when in this case it involved email metadata that is not ever stored as business records or usually even processed by the internet backbone providers from whom it was presumably obtained. So there's a kind of an additional constitutional question in that case, I think. In the case of 702, we know the Supreme Court relied on the recent ruling in Amnesty v. Clapper on representations that only communications to or from specific overseas targets were being intercepted. We now learned, of course, that also communications referring to overseas targets would be intercepted, and that in many cases, for technical reasons, a single email meeting selection criteria would lead to the entire inbox of the communicant being obtained, including, again, potentially entirely domestic emails on what the court believed could be a scale of many tens of thousands per year under that one collection program. In each case, additionally, we learned that for months or years, the actual technical details of how these programs operated were misrepresented to the FISA court, which was, of course, therefore not able to effectively conduct oversight, and that in each case, again, elaborate safeguards and restrictions imposed by the FISA court as a condition of authorizing those programs were effectively neglected because of the vast scale and complexity of those programs. Additionally, in many cases, we found that the claims of efficacy made at the time don't appear to have held up well over scrutiny. From many dozens of foiled terror plots we've gotten down in the case of the telephony metadata case to really one instance involving funding and material support, where it appears to have played some uniquely valuable role. Given the limitations, again, imposed by the FISC, it's not clear why more traditional targeted records orders could not have been used without incidentally sweeping in millions of innocent persons' records. We are assured that the problems detected with these programs have not been willful or intentional. This is not especially comforting to me for several reasons. The first is that if we look to history, we find that, in general, abuses of intelligence powers were committed by people who were well aware of the oversight mechanisms in place, who often took elaborate steps to game those restrictions. In the cases of Bradley Manning and Edward Snowden, we know that it was, there steps were taken to evade oversight mechanism in the case. We know that certainly happened many times in the past, and it's why abuses went undetected for so long. Additionally, the scale of collection itself makes abuse more difficult to detect and less likely to be detected when it does occur. You think of the case of illegal wiretaps of the Southern Christian Leadership Conference's offices. Well, that at least was halted by an attorney general who found the suspicious fact that the wiretap existed and there was a record of it. When you're doing collection on this scale, the mere existence of communications or records about an innocent party are not themselves that kind of essential indicator. Finally, and most generally, I would just encourage the committee to think architecturally. We should not authorize extraordinary architectures of surveillance on the basis that we now have great confidence in the probity of the persons controlling the levers. James Otis, whose condemnation of the writs of assistance was part of the inspiration for the Fourth Amendment, condemned those writs, saying that it is from their mere existence that every householder in the province becomes less secure. And there is a sense in which, while they may serve some role in protecting us against foreign attacks, we are less secure when the government maintains vast databases on Americans without particularized suspicion. I thank you, and I look forward to your questions.
Thank you, Mr. Sanchez. Our final witness is Professor Carrie Cordero, whose bio I have just mislaid. But I'm sure you can get me another one very quickly. Thank you. She is an adjunct professor of law and the director of national security studies at the Georgetown University Law School. She's previously held several national security-related positions with the Department of Justice and the Office of the Director of National Intelligence, and she has also testified before this committee before. So welcome back, Professor, and please proceed.
Mr. Chairman, thank you very much. Thanks for the opportunity to return to the committee. Since the October hearing, the conversation, I would suggest, has shifted somewhat from where it first was. First, I would suggest that the conversation has evolved from objections to specific programs to a discussion of our understanding of and tolerance for foreign intelligence surveillance activities more broadly. Second, the legislative proposals are coming closer to scaling back national security legal authorities in a way that might take the country back to pre-9/11 standards. And third, the path forward on authorized public disclosure in a way that's responsive to the concerns of the private sector remains a worthy goal, but still a significant challenge. With respect to the telephony metadata collection under the business records provision of FISA, an argument increasingly is regarding the power of metadata. And basically this argument is that metadata is a very powerful tool and can reveal an awful lot about us, and there should be limits on the government's collection and use of it. I don't disagree with the general proposition, but the problem with the argument made in the context of the debate on 215 is that the worrisome assemblage of Americans' metadata bears no relation to the existing 215 program that Congress is currently considering. The 215 program does collect an enormous volume of Americans' telephone call detail records, but the collected information does not appear to include content of phone calls, names of subscribers, payment information, or location information. The vast majority of it is never viewed by human eyes, and the records are handled under court order rules. So of the arguments that Congress should outlaw bulk collection altogether, for better or for worse, everyday Americans use the internet to communicate. We all, regular people, government leaders, as well as those who are national security threats, use the internet, computers, and smartphones to communicate. And so just as everyday citizens should not be expected to revert to using only the postal service and landlines, neither should the intelligence community or law enforcement have to resort to pen, paper, and index cards to conduct national security collections or investigations. It is just as unrealistic to expect citizens to unplug as it is to expect or require the NSA or the FBI to use 20th century collection, analytic, or investigative techniques to protect the nation from 21st century threats. A few observations on S-1599, the USA Freedom Act that has been submitted. Sections 101 and 201 would change the legal standards in FISA to obtain business records and implement pen, register, trap, and trace devices by requiring a connection to a foreign power, to an agent of a foreign power. The sections also add a materiality requirement. The likely intended effect of these provisions is to eliminate the 215 bulk telephony metadata program. But the proposed changes would likely have far more reaching consequences for traditional day-to-day investigations. The standards are currently aligned on the national security side with investigative authorities in the criminal context, which operate on a relevance standard. By raising the standard, these sections would render these investigative techniques nearly useless in the early stages of an investigation, which is precisely when they are most useful. These changes could return us to the days prior to September 11th, when it was harder to conduct a national security or international terrorism investigation than it was to conduct an everyday drug or fraud case. Similarly, Section 501 would amend the collection of statutory authorities known as national security letters by requiring the requested records to also have a connection to an agent of foreign power. This would have a similar effect in terms of severely limiting the FBI's ability to conduct timely and thorough national security investigations. Another section, Section 301, would appear to prohibit the intelligence community from querying data acquired pursuant to Section 702 of FISA to search for U.S. person communications. Under the current minimization procedures approved by the court, the NSA can query the communications already acquired under 702 for U.S. person communications. The proposed legislation would only allow the same query to take place if the U.S. person is a current target of a criminal wiretap or FISA coverage, which would require prior judicial approval based on probable cause. This proposal could arguably prohibit the intelligence community from querying already lawfully acquired data to search for the methods of communication of a valid target who happens to be also American. And in my written statement, I give an example of how I think this could potentially play out in practice. A few words just on a particular proposal to enhance transparency that's in the bill. In my view, there's substantial value in Congress continuing to work with the executive branch and the private sector to rebuild confidence between them, and for the government to help the private sector restore confidence with consumers, customers, and investors. But a particularly problematic proposal is Section 602 of the bill. It proposes that the government disclose the number of persons subject to electronic surveillance. I believe that this is intended to include not only targets, but persons whose communications are incidentally collected. If that's the intent, in my view, this provision would actually degrade privacy protections, because a requirement to report on the numbers of persons collected would require that the intelligence community personnel look at, read, review, count, and keep records apart and report on information that otherwise they would disregard in pursuit of their actual mission of discovering, analyzing, and reporting on foreign intelligence information. So again, thank you for the opportunity to be here today, and I look forward to your questions.
Thank you very much. Let me start with a question for Mr. Black. There is legitimate concern that the knowledge of our national security activities casts a shadow on the ability of American companies to compete internationally. That was the basis of your testimony. Do you believe that foreign customers believe that, for instance, if they sign up for a service with Huawei, that the Chinese government is not looking into this data, or the Russian government if they sign up in areas under its jurisdiction, or the French government for that matter? Do you think that the United States government is actually the only government that is trying to take advantage of big data?
I hope our standard isn't just to meet Huawei, but I do think the reality is that governments in general are inclined to want more and more information, too much. That's why what we address in our testimony is, in fact, standards that all governments should be asked to undertake in terms of disclosure, in terms of limits. The difficulty is that the United States is in a difficult position in credibility when we are seen to have an extremely pervasive, effective, widespread, and some would say not effectively limited process. No, by no means do we want to defend anybody else.
The Chinese and the Russians actually are more effectively limited by the government
I'm not
performing this
suggesting
kind
that
of surveillance activity than the United States is?
No, I'm not suggesting, I'm not doing a comparison. I'm simply saying that I don't think most people, the citizens and the customers of the world, think that United States laws, I think, first of all, I believe we do have some checks and balances that have some effectiveness. Don't get me wrong. You asked the question of the perception of the
Indeed, they are far
world.
better than any other countries' checks and balances that are engaged in this kind of behavior, correct?
I'm not going to talk to all other countries. I certainly hope we have better ones
Are
than
you
China
aware
and
of
Russia.
any other country that has a better?
I think there are
oversight?
many other countries that don't probably do as much collection as we do.
I can name some. There are some very tiny little countries that probably barely run a phone system. But in terms of our major competitors, in terms of the major economic and political actors on the world stage, the ones that I think we're all thinking of,
I guess the question
none of
we're
them
trying to
have more
say,
robust protection.
what kind of
than we
future do we
correct?
want? What kind of internet we want? Do we want an open internet which provides tremendous economic growth, tremendous empowerment, tremendous diplomatic and political opportunities around for billions of people around the world? Do we want one where people can have association with other people without being spied on by their government or our government or any other government? Is that a desirable outcome? If so, how do we take steps to move in that direction? Or do we accept the reality that all governments are going to do a maximum collection and go in the big brother direction as far as they can go? And we're just in an arms race to do that? I don't think that's a future I look forward to. It's difficult to want to restrain a government's desire for more information, especially, I think, our government, where we have well-motivated people who care about national security, who really do believe in the motivation of what they're doing, but they are zealous and effective, and they are, in fact, in a position where they are able to gather a great deal of information.
So you think our government security services are more dangerous to civil liberties than the government security services of China and Russia?
Are they more interested? Absolutely. Much more interested in protecting civil liberties. Absolutely. No doubt about it.
Intruding into civil liberties. You agree that our government oversight of our national security establishment is far more interested in protecting civil liberties than those of competitors like China and Russia?
Well, again, I can't compare to other people. I don't know the details. I certainly have a presumption about how ineffective any control they would have. I would hope that with our Constitution we would have a really effective system. Do I think we have lived up to the best intent and good faith of our Constitution with the legal structures we've created that allow the surveillance? No, I don't think we lived up to the principles, the core principles of the First Amendment and Fourth Amendment as faithfully as we could. Are we better than totalitarian regimes? Of course. That's not a question I think is fair.
You take a different view, I guess, than the courts that have overlooked this, which have not found Fourth Amendment violations in any of this.
I think some of those decisions have historical positions that are based. I mean, business records, for example.
But there's no present
when the business
decision
record
that supports your legal point of view.
Excuse me?
There's no present decision by any court that suggests that there's been that this is operated in violation of the Fourth Amendment. It would take a new decision to make that conclusion that has not yet been rendered by any court. Is that not correct?
I'm not confident enough. I have some great counsel that work for me on all the details. I would suggest that various efforts to get those questions raised in the courts have been denied.
You're the one who said that this was being operated in violation of the Fourth Amendment. I'm asking you if you can cite a case that supports that proposition.
Counsel, is there a specific? I believe the FISA court made ruling that certain practices had violated the
orders.
The orders. Well, I think the orders were based on the Constitution.
Professor Cordero, for how long has incidental collection of communications with people who are not the subject of the warrant been a fact of life in law enforcement?
Well, both on the criminal side and on the national security side, there always is going to be incidental collection. So the criminal Title III wiretaps handle it in one way. On the national security side, it's handled through minimization procedures for U.S. person communication. So it's always been a factor. The minimization procedures, particularly on any of the FISA minimization procedures are approved by the court, including on the 702 collection.
So for as long as there has been any authorized government interception of communications, incidental collection has always been a part of that, necessarily.
Right. That's right.
I've gone over my time. Senator Blumenthal is here. Let me yield to the distinguished senator from Connecticut.
Thank you, Mr. Chairman, and thank you all for being here.
let me focus on FISA court reforms. Mr. Sanchez, I wonder if you could tell me your position on implementing some kind of adversarial process, as I have advocated be done through a constitutional advocate and other reforms in the FISA court that might be feasible.
So I would step back from that for a moment and just say that in cases where you have something that is an authority that was clearly, I think, envisioned as something relatively targeted to acquisition of records with some nexus to terror or espionage suspects, the appropriate move at that point, if it's believed that some kind of bulk collection is necessary, some kind of more programmatic use of that authority is necessary, is to return to Congress and not to, in fact, leave that decision in the hands of the FISA court. Warren Kerr suggested approaching this with a rule of lenity. However,
in other words, the FISA court should not be making law.
When a request is so broad as to effectively, I think, exceed what anyone conceived as the authority, it would be better to have congressional authorization. In closer cases, I think what we can see from some of the opinions that have now been released first is that it would, I think, benefit the court's proceeding when novel questions of law are present to have some kind of adversary or amicus to raise opposing arguments, but also, I think, in particular, to have technical expertise. I alluded briefly earlier to a kind of tricky constitutional wrinkle with respect to the use of pen register authority to intercept internet metadata, where you don't just have, as with a phone call, the number and the content, but layers of metadata and content with content at one level.
You think, though, that we ought to have a constitutional advocate?
I think that would be extraordinarily helpful, but also I think a technical advisory capacity of some kind would be useful, because sometimes I think the most difficult questions turn not just on the abstruse details of law or technology, but about the ways they intersect in surprising ways where often there isn't precedent directly on point.
Thank you. And Professor Cordero, I gather you feel there is no need for a constitutional advocate or some kind of adversarial process, but you would be willing to support some kind of amicus curiae process.
Thank you, Senator. Well, so certainly since the October hearing, I mean, this conversation has evolved. And so, there are different proposals. In my view, as we discussed at the prior hearing, based on the current procedures that take place within, between the Department of Justice and the intelligence community and the court, in my view, I think that the current process is sufficient, that facts from the other side are presented to the court. The court has independent legal advisors. These are independent Article III judges who make judgments on their own. So in my view, there actually doesn't need to be an adversarial process, and I think the current process is sufficient. However, between the competing legislative proposals, between establishing an office of a special advocate versus the proposal to enable the court to call upon an amicus if the court believes it needs it, I believe that the second option would be the better of the two options.
And that's because you're loath to create a quote-unquote bureaucracy, or what is the reason?
Sure. So several reasons. So one is yes, I think that the FISA process already is very heavily bureaucratic. It's heavily lawyered. There's multiple offices and legal offices and different layers of management that are involved in reviewing FISA matters. So I think it already is very bureaucracy heavy, and I think that the way that the Office of Special Advocate is described in these legislative proposals, that it would simply add to that process. I also am concerned that over time, there has been a relationship of trust and a very constructive relationship between the executive branch and the FISA court. And I actually worry that an Office of Special Advocate would in some way harm that sort of established relationship of trust by being in the middle. With respect to the proposals to add an amicus, again, if the court...
Isn't the problem that this relationship of trust has actually undermined trust in the American public and really threatens to completely eviscerate confidence in a system that operates in secret, makes secret law, and in the end, the relationship of trust may undermine the whole system.
Well, although, Senator, I would say that actually a concern about the Office of Special Advocate is that it will have to operate in secret too. And so just as the creation of the FISA court in 1978 and the creation of the office that worked in the Justice Department that was an independent, non-political office at the time was created in order to establish trust and be sort of this independent participant in the process, now people don't, they're questioning the FISA court. And so I don't know that although in the sort of immediate future, I can see how the Office of Special Advocate might be appealing. I don't actually think in the long term, because it will operate in secret, because it will sort of become part of this whole process, that in the long term it really will restore
Well, it
that.
would operate in secret, but it could be combined with other reforms that would provide for some greater measure of transparency to the FISA court's opinions when it makes new law that affects Americans around the world, or at least in our country. Perhaps there ought to be more of these rulings and opinions that are made public. But at any rate, my time has expired. I thank you, Mr. Chairman, and thank each of the witnesses for being here today.
Thank you, Senator Blumenthal. I'm also grateful to the witnesses for the trouble that they've taken to come in and help inform this committee as we go about our decisions, and I welcome them. And we have 2 weeks? 1 week. Okay. We will hold the record of this hearing open for 1 additional week for any further materials anybody wishes to submit. And with that, we will adjourn the hearing.
Okay.